Hey everybody, Justin Stivers, owner of the Probate Law Firm here, doing part 5 of a 5-part series, doing videos on topics that when you're speaking with your probate attorney, maybe going in for your initial consultation, some things you should ask or be aware of that that I find most people don't really ask about. And so in this last video, I'm talking about spouses and children from another marriage. So in today's age, pretty common where someone gets married, they get divorced, but they maybe had kids with that first spouse, and then they remarry, maybe later on in life. And so this comes up in probate all the time. Generally here in Florida, if a person dies without a will, so they didn't have anything in writing saying who gets what of their stuff after they pass away, everything would automatically go to the surviving spouse. So if husband dies and wife is still alive when husband dies, anything that husband had would go to her. But this becomes a little bit interesting when there's children from a different marriage or from a different spouse. So let's say that husband dies, but he had children from a previous marriage, and he didn't have a will written. Well, now it's very likely that under Florida law, those children from the first marriage are probably going to get a large percentage, up to maybe 50% of whatever he had. And where we see this is, a lot of times there might be these might be children that weren't really around, or maybe even if they were around, maybe it was understood he wanted everything to go to the spouse, to his wife. But if he didn't write that down, the children are going to be entitled to a large percentage of whatever it is he has. So, a lot of times I think the surviving spouse just kind of thinks that, well, he's my husband, it's my wife, I automatically get what he had, what she had, and often that is the case. But if there are children that the person had from a different marriage or from a different person, those kids might get something. The way to get around this is, if you don't want your kids and wife or husband to fight, which this happens all the time, where maybe the stepkids don't get along very well with their step parent. So I would highly recommend put something in writing, do a will, do a trust, basics, just something very basic. Well, probably more complicated, but do something at least basic to say who gets what, because the last thing you want is for a huge family feud, and this is one of the biggest sources of family feuds, where all this pent up anger, maybe, or frustration between the stepkids and the step parent comes out after the parent dies. So I hope you guys found this series useful. If you have any questions, as always, leave comments below, or give the Probate Law Firm a call. Our website is probatefirm.com, and happy to help. Talk to you guys soon.